The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to explain surviving children's rights in Illinois probate. So this is surviving spouses and children have certain minimum amounts that they're entitled to from an estate, even if that amount is not left to them in a will or a trust. So if that amount is left to them in a will or a trust, then great. But if not, there's certain minimum amounts that they're entitled to. Now, we've got a different article and video about a surviving spouse's rights, so we're not going to go into too much detail here about that. So we're going to focus on children's rights, and really you only have rights if you are a minor child or an adult child with a disability. So if you're an adult child that is not a minor, you don't have a right to make a claim against the estate just by virtue of you being a child, unless there's no will and state intestacy laws, make you the heir. So we're talking about a situation where you're not already the heir and the will doesn't already leave you the minimum amounts we're talking about. So let's first talk about it. We're going to talk about a couple of different scenarios. One is when there is a surviving spouse and the child lives with the surviving spouse. Another is when there's a surviving spouse and the child does not live with the surviving spouse. The awards work a little bit differently there. Another is if there is no surviving spouse and there are minor children involved. Another scenario is when there's adult children with disabilities not residing with the surviving spouse. So we will cover all of those, and then we'll talk about the difference between what happens when there is a will and when there isn't a will. But first, let's talk about when there is a surviving spouse and the child lives with the surviving spouse. So, as we discussed a minute ago, surviving spouses are entitled to a particular claim against the estate. They can get a minimum of $20,000, whether it's left to them in a will or not. And this is to cover the basically support for that person for the 9-month period after death. So courts can award more than that if necessary, but it's a minimum of $20,000, assuming the estate can afford it. If there are minor children living with the surviving spouse gets $10,000 per dependent child living with him or her at the time of death. So in this case, if the child is living with the surviving spouse's award is increased, but there's no separate child's award. If there's a surviving spouse and the child does not live with the surviving spouse, and now again we're talking about only minor children here, the surviving spouse doesn't get that additional $10,000 per child. Instead, there is a child's award of a minimum of $10,000 given to the childs themselves, and this can be either done given to their guardian through a guardianship of the estate or a custodianship. We've got videos and articles about how those things work. But the court can award a higher amount based on the needs of the child or the child's standard of living during the lifetime of the deceased person. So if there's a minor child and there's no surviving spouse, so far in both of the scenarios we talked about, there was a surviving spouse, but we were just discussing whether the child lived with the spouse or did not. Now we're talking about a scenario where there's a minor child and there is no surviving spouse. In this case, the children each receive a $10,000 child's award, like the one we just talked about, which can be more based on the needs or standard of living of the children. Plus, they get what would have otherwise been the spouse's award, $20,000, that is divided equally among them. So if there's no surviving spouse, what would otherwise be the spouse's award is divided equally among the minor children, in addition to the $10,000 children's award. And we should note that the children can elect to receive any of these awards instead of in money. They can receive them in goods and chattels, meaning tangible personal property. So if there's an expensive car involved, they can say, I'll take the car, and then reduce the rest of the award. So that's how it works for minor children. If you are an adult child with disabilities not residing with a surviving spouse, you also have some rights here. You can get a minimum award of $5,000, and that's a minimum, but the award should be consistent with the financial support you received from the person that is deceased during that person's lifetime. So if you were getting basically a lot of financial support from the deceased person and there's money in the estate to cover it, then you're going to get much more than the $5,000 award. However, in order to receive the award, you have to have been financially dependent on the deceased person at the time of the deceased person's death, and also likely to become a public charge if the award isn't given. You also have to send notice to the estate's representative that you are entitled to this award within a certain deadline, and this is time sensitive, and if you don't send notice within the deadline, you forfeit your right to the award. So you should definitely get an attorney to help you and make sure that you comply with the notice requirements and not forfeit any award to which you might be entitled. So those are the different scenarios. There's one last layer to add on top of this, and that's whether or not there's a will. If there was a will, children are entitled to a share of the estate if they were born after the will was created. So if the will just says to my two children, Bobby and Tammy, and Marjorie was born after the will was created, that doesn't disinherit her from what she would otherwise be entitled. However, a will can explicitly disinherit children from the children's award we discussed earlier. So if the will says everything to Bobby and Tammy, but I want Marjorie to get nothing, then Marjorie is not going to be able to get her $10,000 child's award that she would otherwise be entitled to receive. So if there's a will that explicitly disinherits a child, then they're not entitled to any of the awards we talked about. If there is no will, then intestate succession determines what you're going to get. And so that's basically that's a state statute, and we have a video on this, so I won't go into a ton of detail. But it's a state statute that says in the absence of a will, here's who is entitled to inherit your property. And if there's a surviving spouse and surviving children, then half of the estate goes to the surviving spouse, half of the estate goes to the surviving children divided in equal shares. If there is no surviving spouse, then the entire estate is divided among the surviving children. So if you have any questions, please post a comment below this article at learn-about-law.com or below the YouTube video on our YouTube station. We try to respond within about 24 hours and give you good answers to your questions. If you found this helpful, we would love it if you'd subscribe to us on YouTube, iTunes, and SoundCloud. If you'd like a free consultation, please feel free to give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in nearly every area of law, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.